Imagine standing on a quiet street late at night. A police car slowly pulls up beside you. The window rolls down and an officer says, "Hey, can we talk for a moment?" You pause. Your heart beats a little faster. You're not in handcuffs. You haven't been told you're under arrest, but you're also not completely sure what your situation actually is. Are you free to leave? Or are you already in police custody without realizing it? This exact moment, the confusing space between freedom and arrest, has quietly shaped thousands of court cases, police encounters, and legal debates for decades. And yet, most people don't fully understand what's happening during those first few minutes of interaction with law enforcement. So here's a question for you. If a police officer stops you on the street or during a traffic stop, how do you know whether you're simply being detained or if you're actually under arrest? Take a moment and think about that. If you've ever been pulled over, questioned by police, or even just wondered about your legal rights during an encounter, share your thoughts in the comments. Most people are surprised when they learn the real legal difference between these two situations, because in the eyes of the law, the difference between being detained and being arrested can completely change your rights, what the police are allowed to do, and what may happen next. To understand why this distinction matters so much, we need to begin with a simple but powerful principle that sits at the heart of modern criminal law. In most democratic legal systems, people are presumed to be free. That means you can walk down the street, drive your car, go to work, talk to friends, and move about your day without government interference. Law enforcement officers cannot simply stop anyone at any time without a lawful reason. This principle exists because of a long legal history that stretches back centuries through court decisions, constitutional protections, and hard-fought legal battles over personal liberty. But the law also recognizes something else. Police officers have a duty to investigate crimes and protect public safety. To do that, they sometimes need the ability to temporarily stop someone, ask questions, or investigate suspicious circumstances. And that's where the concept of detention begins. A detention is a temporary restriction of your freedom. It means the police have stopped you, and for the moment, you are not free to leave. But, and this is the crucial point, a detention is not the same thing as an arrest. In legal terms, a detention usually happens when an officer has what courts call reasonable suspicion. Reasonable suspicion is a legal standard developed through decades of court rulings. It means the officer must be able to point to specific facts that suggest a person may be involved in criminal activity. Not just a vague feeling, not just curiosity, but observable facts that justify briefly stopping someone to investigate. For example, imagine an officer receives a report about a burglary suspect wearing a red hoodie and black backpack who was last seen running through a particular neighborhood. Minutes later, the officer sees someone walking nearby who matches that description. At that moment, the officer may have reasonable suspicion to stop the person and ask questions. That stop would be considered a detention. The person is temporarily not free to leave while the officer investigates the situation, but the officer does not yet have enough evidence to make an arrest. This concept became one of the most important principles in modern policing after a landmark United States Supreme Court case in 1968 known as Terry v. Ohio. In that case, a police officer in Cleveland noticed two men repeatedly walking back and forth in front of a store window, appearing to study the location. The officer suspected they might be planning a robbery. He approached them, questioned them, and conducted a limited search for weapons. The case eventually reached the Supreme Court, which ruled that officers may briefly detain and question individuals if they have reasonable suspicion that criminal activity may be taking place. This decision essentially created what many legal experts call a Terry stop, a short investigative detention, not an arrest. And that distinction has shaped police encounters ever since. Now here's where things become even more interesting. During a detention, your rights are different from what they are during an arrest. But the situation can also feel confusing because many of the outward signs may look similar. You might be asked to stop walking, you might be asked questions, you might even be instructed to keep your hands visible or remain where you are. From a legal perspective, courts generally look at one key question to determine whether someone is detained. Would a reasonable person feel free to leave? If the answer is no, then legally speaking, that person is likely being detained. But remember, a detention is meant to be temporary. It's an investigative pause, not a formal accusation. An arrest, on the other hand, is something much more serious. An arrest occurs when police have what the law calls probable cause. Probable cause is a higher legal standard than reasonable suspicion. It means there is sufficient evidence to believe a person has committed, is committing, or is about to commit a crime. Once probable cause exists, officers may place a person under arrest. And when that happens, several things change immediately. First, your freedom of movement is completely restricted. You are taken into custody. Second, officers may conduct a more thorough search of your person. Third, you will typically be transported to a police station or detention facility. And fourth, your legal rights, including the well-known Miranda rights in the United States, become especially important during questioning. But here's the part that often surprises people. A person does not always hear the words, "You are under arrest," at the exact moment an arrest legally occurs. Courts often determine an arrest based on the situation itself. If a reasonable person would believe they are not free to leave and the restraint is more than temporary, the encounter may legally qualify as an arrest. This means that the line between detention and arrest can sometimes blur during real-world encounters. And this legal gray area has led to countless courtroom arguments over the years. Defense attorneys may argue that a detention went too far and effectively became an arrest without probable cause. Prosecutors may argue that officers were still conducting a lawful investigation. Judges must then examine the facts carefully. How long did the stop last? What actions did the officers take? Was the person handcuffed? Were weapons drawn? Were they transported to another location? Each detail can matter, because if a court determines that an arrest occurred without probable cause, any evidence obtained afterward may be ruled inadmissible. This rule exists because courts want to discourage unlawful arrests and protect constitutional rights. And that brings us to an important practical question. How long can a detention last? The law generally says it must be reasonably brief, long enough to confirm or dispel the officer's suspicion, but not unnecessarily prolonged. In many cases, this might mean a few minutes while an officer asks questions, checks identification, or verifies information. If the officer's suspicion turns out to be unfounded, the person must be allowed to leave. If evidence of a crime appears during the investigation, the situation may escalate to an arrest. But the detention itself must remain limited in scope and duration. Of course, the real world is rarely as simple as legal definitions. Police encounters can be tense. Officers must make rapid decisions based on incomplete information, and individuals may not always understand their rights or the legal status of the encounter. This is why courts repeatedly emphasize the importance of objective standards. They ask whether a reasonable person in the same situation would believe they were free to leave. Think about that idea for a moment. If you were stopped by police and surrounded by officers, flashing lights and authoritative commands, would you feel free to walk away? Most people would not. And that's exactly why these legal distinctions matter, because they determine when constitutional protections apply and when law enforcement authority must be carefully limited. The difference between detention and arrest may sound like a technical legal concept, but in reality, it plays a central role in everyday interactions between citizens and the justice system. Traffic stops provide a perfect example. When an officer pulls a vehicle over for a traffic violation, the driver is considered detained, not arrested. The stop is temporary and limited to the purpose of addressing the traffic violation. The officer may request a driver's license, registration, and proof of insurance. They may ask questions related to the stop. But unless additional evidence arises suggesting a crime, the encounter should end once the matter is resolved. However, if during the stop the officer observes evidence of illegal activity, such as signs of intoxication or contraband in plain view, the situation may change. At that point, probable cause may exist for an arrest, and suddenly the legal nature of the encounter shifts. This progression from detention to arrest has occurred in countless real-world situations, some of them routine, others dramatic, some even historic. Consider major criminal investigations where a suspect was first detained for questioning before evidence emerged that justified an arrest. Detectives often use investigative detentions as a way to gather information quickly while maintaining public safety. But again, the law requires that these detentions remain grounded in reasonable suspicion. Without that foundation, the stop could be considered unlawful. And courts take that issue very seriously, because history has shown that unchecked authority can lead to abuse. The legal safeguards surrounding detention and arrest exist precisely to balance two competing needs: the need for effective law enforcement and the need to protect individual freedom. That balance has been debated in courtrooms, legislatures, and academic circles for generations, and it continues to evolve as society changes. New technologies, new policing strategies, and new legal precedents constantly reshape how these principles are applied. Yet the core idea remains remarkably consistent. A detention is temporary. An arrest is a formal taking into custody based on probable cause. Two very different stages of a legal process, and understanding that difference can help people navigate one of the most stressful experiences anyone can face, an encounter with law enforcement. Now here's something worth thinking about. If you were stopped by police tomorrow, would you know how to tell whether you were being detained or arrested? Would you recognize the legal signals that the situation had changed? Many people assume the difference is obvious, but as courts have repeatedly shown, the line can sometimes be subtle. And that subtlety has shaped countless legal cases over the years. Because when freedom is at stake, even small distinctions can carry enormous consequences. Understanding those distinctions isn't just something lawyers and judges care about. It's knowledge that affects ordinary people during ordinary moments. A walk down the street, a traffic stop, a brief conversation with an officer. Any of these situations can become a detention, and sometimes, though far less frequently, they may escalate into an arrest. The law tries to draw a clear boundary between those two stages. But in real life, that boundary is defined not by dramatic announcements, but by legal standards, facts, and the perceptions of a reasonable person in that moment. So the next time you see a police encounter unfold, whether on the street, in the news, or even in a courtroom story, remember that what you're witnessing may involve one of the most important distinctions in criminal law, a temporary detention or a full arrest, two terms that may sound similar. But legally, they represent very different realities, and as you think about that difference, consider sharing your perspective. Have you ever experienced a situation where you weren't sure whether you were being detained or free to leave? How did you handle it? Your experiences and thoughts add valuable insight to a conversation that affects millions of people every year. Because understanding the law isn't just about courtrooms and statutes. It's about knowing where authority ends, where rights begin, and how the balance between the two shapes everyday life. And in the quiet moment when an officer says, "Can we talk for a moment?" that knowledge can make all the difference.